Afternoon, everyone, and thank you for coming. I hope everyone is well during this rather strange period of time. It's also been obviously a very difficult period of time for millions of people worldwide, not just in the United States, not just in New York, and difficult on a personal, social, and economic level. In the United States, as we know, Congress has recently passed laws, an array of laws, I should say, that are aimed at helping employers and employees during this COVID pandemic. However, the new laws and the numerous provisions that have been created have also created confusion among many people, with the result that government has had to issue a number of interpretations and guidelines concerning these new laws, which naturally comes as a result of laws that are sometimes passed rather hastily, but in this case, in an effort to provide some quick assistance to businesses and to individuals during this period. So I'd like to begin by clarifying some of the confusion by providing information in a general and categorical way without getting too much into the details, because these provisions are rather complex, especially the tax-related provisions, and are changing on a weekly, if not daily basis. So each of these different laws that we'll touch upon today could easily be the subject of its own webinar. So I'm going to try to address them in a very general way. A word of caution, though, the devil is in the details. So there are numerous provisions that affect eligibility for assistance and numerous conditions that are attached to the assistance programs. So the webinar is not really about helping anyone apply for assistance. Rather, it is about giving you a general overview of what is available and the challenges that are faced by employers and employees. So with that said, we will begin by clearing up the confusion by understanding the names of the various laws, the acts that have been passed, and the chronological order in which they were enacted to give context and overall meaning. Then we will analyze the particular provisions and provide some guidance for employers and employees, and see how these programs are designed to assist them. And then finally, we'll look at some problems and pitfalls that have already arisen with the new laws. And then at the end, as Anna said, we will do some question and answer. We'll reserve some time, 15 minutes or so. So please hold your questions until the end. Okay, so navigating the challenges means first understanding the laws, the different laws. We'll go through this rather quickly. The first law that was passed was the Coronavirus Preparedness and Response Supplemental Appropriations Act that was passed on March 6th. Just over 2 months ago. This essentially was the appropriations bill that enabled Congress to afford, I don't know how many trillions of dollars to pay for all of these assistance programs. Immediately after that, within a couple of weeks, Congress passed the Families First Coronavirus Response Act, otherwise known as the FFRCA. You will see a number of acronyms throughout this webinar. The reason for the acronyms is obviously because these laws have very long names, and so they have shortened them to the acronyms. So the FFRCA was enacted on March 18th, and there are two major components to the FFRCA. One is the Emergency Paid Sick Leave Act, and the other is the Emergency Family and Medical Leave Expansion Act. We will look at both of those. The third major piece of legislation was enacted about a week after that, the Coronavirus Aid, Relief, and Economic Security Act, otherwise known as CARES. That was enacted on March 27th. And again, there are two major components to that law: the Paycheck Protection Program, the PPP, and the Emergency Injury Disaster Loan Program. Now, there are other components to CARES, which we will briefly look at, but these are the two major ones. So let's take a look at the FFRCA first. This law primarily provides financial assistance for paid sick and family leave, unemployment insurance, and COVID testing and diagnosis. Under the emergency paid sick leave law, the law, first of all, applies to employers with less than 500 employees. If they have less than 500 employees, the employer is required to provide paid sick leave to any employee, regardless of the duration of the employment, for reasons associated with COVID. That means, very importantly, if an employee was employed for the first time by an employer on April 1st, and 4 days later had to leave because of a COVID-related issue, then that employee would be entitled to paid sick leave, even though he or she only worked for 4 days. The employee would also be entitled to up to 80 hours or 2 weeks of paid leave if they're full-time. All right, so this is a very significant law in the sense that it doesn't matter how long the employee was employed by the employer, he or she is entitled to this leave, even if they worked a couple of days, and they're entitled to up to 2 weeks of paid leave. The amount of the compensation that is available to the employee is whatever they are being paid, but capped at $511 per day if they are directly impacted, or $200 per day if they are impacted indirectly, in the sense that they have to care for someone else in their family. Small businesses with less than 50 employees may qualify for an exemption. Okay, so more than 500 employees, they're not obligated. Less than 500 employees, they are, but if they are smaller than 50 employees in size, they could qualify for an exemption. Now, there are certain limitations on the EPSL. It is only available to employees who are subject to a quarantine or isolation order, or they've been advised by a healthcare provider to self-quarantine, or they're experiencing symptoms of COVID and are seeking a medical diagnosis. Those are the only instances in which the EPSL is available to the employee. And there are other provisions also associated with this sick leave. The employees cannot be required to use other paid time off. In other words, if the employer has a program, a policy, whereby employees are entitled to vacation pay or other sick leave pay, the employer cannot tell the employee that they must use up that vacation time or that paid sick leave before using the emergency paid sick leave. It runs concurrently, so they're entitled to both. Okay. The employers must provide notice to the employees of their rights to emergency paid sick leave. And also importantly, the emergency paid sick leave is not preempted by federal, state, or local law. Meaning, if there are laws, for example, in the state of New York that has paid sick leave, those laws do not preempt the EPSL. If the law of the state or the locality provides for lesser paid sick leave, less than 2 weeks, for example, the employer cannot say that that law will apply and preempt the EPSL, so therefore I only have to give 1 week instead of 2 weeks. It doesn't work that way. This law was enacted so that it was primary, or it is primary. So to Congress understanding that this could really be a burden on some employers to have to pay for 2 weeks of paid sick leave to all employees, financially, especially in this environment, could be very problematic. The law also requires that the employer get tax credits in the form of payroll tax credits. And this is essentially to defray the cost to the employer. So what are employers entitled to? They are entitled to a tax credit to a maximum of $511 per day or $200 per day, depending on the reason for the leave. The same limitations that are applied to the employee as a cap on wages apply equally to the employer on the tax credits. They're entitled to a dollar-for-dollar offset against their payroll taxes. And these wages that are paid to the employee are not subject to the employer portion of Social Security taxes. And I should add to the slide, Social Security and Medicare taxes. So I'm not sure how familiar everyone is about how payroll taxes work, but from the employee's paycheck, there's a deduction for Social Security and Medicare of approximately 8%. That is matched by the employer on the employer's side. So the employer pays an equivalent 8% or so of Social Security and Medicare tax contribution. Well, for the wages that are paid under the EPSL, the employer would be entitled to a tax credit for the employer's portion, that 8% that it pays on behalf of the employee. So again, this payroll tax credit is built into the laws to defray the cost to the employer for having provided the emergency paid sick leave. As I said before, there are states and localities that have their own paid sick leave. So since we're in New York, I would highlight the fact that New York State has its own paid sick leave law. And under this law, employees that are subject to mandatory or precautionary quarantine orders are entitled to protection, depending on the category of the employer. So we'll take a quick look at this, the different categories that New York has determined. The first category being employers with 10 or fewer employees and a net income of less than $1 million last year. They must provide the employee with guaranteed job protection for the duration of the quarantine order. They must provide paid family leave and disability benefits through the employer's existing policy if they have one. And they must be paid their salary for the duration of the quarantine order to a maximum of $2,884.62 per week. In the second category of employers, those with 10 or fewer employees and a net income of more than $1 million, it's the same guaranteed job protection. Everything is the same except that they must also afford at least 5 days of paid sick leave to the employee. With employers of 11 to 99 employees, regardless of income, they have to provide guaranteed job protection, at least 5 days of paid sick leave, and again, the employee would be eligible for any paid family leave or disability benefits through an existing policy. Same salary max applies here. The difference here is the employer is a larger employer, and it doesn't matter what their net income was last year, they would still have to provide these benefits under New York law. There's two more categories in New York. Employers with 100 or more employees must provide guaranteed job protection and 14 days paid sick leave, not 5, but 14. And for public employers, that means governmental employers, whether it's federal, state, or local government or agencies, regardless of the number of employees, they must provide 14 days of paid sick leave. Okay, so there's a second major component to the FFRCA, and that is the Emergency Family and Medical Leave Expansion Act. Here, this law essentially expands the provisions of the FMLA. Now, many of you, I'm sure, are familiar with the FMLA, the Family Medical Leave Act. And this law essentially expands that. How does it expand it? Well, it says that employees with a qualifying need who have worked at least 30 calendar days are eligible for this expanded leave. Qualifying need is defined as an employee who shows that he or she is unable to work or telework. Okay, very important. If they can work from home, this does not apply. But if the employee is unable to work or telework due to a need for leave to care for his or her child younger than 18 years of age, if the school or the place of childcare has been closed or the childcare provider is unavailable, then they would be entitled to this leave provision. What is it? Essentially, it's complicated, but essentially it boils down to the employee being entitled to the first 10 days of leave. Okay, in those first 10 days, the employee may use any available paid time off, including vacation, personal time, medical leave, or sick leave, without penalty. After the 10 days, the employees are paid not less than 2/3 of their salary to a maximum of $200 per day, or an aggregate of $10,000 for up to 12 weeks in a 12-month period. Okay, so first 10 days of leave, they're entitled to take it as paid time under the existing policy of the employer. After 10 days, they get 2/3 of their salary up to those max limits. Here, there's another limitation that employers with fewer than 25 employees may also be exempt from this provision. Similar to the EPSL, the government has put in some payroll tax credits for the employers, again, to defray the cost of providing this expanded leave. And here, similarly, there's a refundable tax credit for wages that were required to be paid, equal to 100% of the wages paid. So if they paid for 10 days, for example, of leave time, they would be entitled to tax credit for those 10 days. The credit, though, is capped, again, similar to the EPSL, at $200 per day or $10,000 in the aggregate. And the wages are not subject to the employer's portion of Social Security and Medicare taxes. In a sense, these payroll tax credits are a way of telling employers that giving employees this leave will not cost them any more than it should. Whether it's a direct offset or it's an equal offset, that's to be seen, and that's really the question for the accountants and tax experts. But in theory, it should be a direct offset to the employer. Okay, so under the FFRCA, they also have provisions for unemployment insurance, and not to leave the states out of this assistance. The states will also get benefits because it's the states that provide the unemployment insurance to employees. To help or assist the states in providing what has amounted to massive increases on the unemployment rolls, the FFRCA says that employers who provide employees with notification of their unemployment eligibility, I should say that these conditions must be applied to the states in order for them to get the benefits afforded by the government, the federal government. So first, employers have to provide the employees with notification. Secondly, the states have to provide at least 2 ways to apply for benefits, for example, online and on the phone. And then the states have to notify every unemployment applicant when the application is received and being processed, and provide information about how to ensure successful processing. So if the states do that, then they will be entitled to benefits under the FFRCA. There's also emergency grants that are afforded to the states that experience at least a 10% increase in the unemployment rates for that particular state. So again, this is in aid of having the states provide the additional unemployment compensation to the thousands of laid off employees. And lastly, under the FFRCA, there are provisions for COVID-19 testing and diagnosis. The cost of testing and the provider visits are covered for office visits, urgent care visits, and emergency room visits. The charges must be covered without any co-pays, without co-insurance or deductibles. No prior authorization is required for this specific type of testing, and it should apply to most health insurance plans or self-funded group health plans or Medicare and Medicaid. Okay, so looking at the last piece of legislation and probably one of the more significant pieces of legislation, the CARES Act. Again, this has many components. We'll try to touch on a few of them. The first component is the small business loans component. Here, employers with fewer than 500 employees are eligible for loans to be used for payroll and other expenses, such as insurance premiums, mortgage interest, rent, and utilities. The original bill called for $370 billion, but that was depleted almost instantly by mid-April. So on April 24th, the government passed an additional appropriations bill for $310 billion applied to two programs, the Paycheck Protection Program and Healthcare Enhancement Act, which encompasses the Paycheck Protection Program and the Economic Injury Disaster Loans and the Economic Injury Disaster Grants, otherwise known as EIDL, E-I-D-L. All right, so they ran out of money very quickly for these small business loans, but then appropriated some additional loans for small businesses for essentially paycheck protection. And I'll show you how this works. Under the Paycheck Protection Program loans, small business owners can apply for these loans through the Small Business Administration. They will not be subject to any fees that are normally tacked on by the SBA, and the loans will be deferred for at least 6 months and up to 1 year. Under the loans, the loan program, rather, the employer can borrow up to 2.5 times its monthly average payroll. Okay, so remember, these loans are supposed to be of short duration. So 2.5 times monthly average payroll is what can be borrowed. The law also provides for forgiveness of the loan, okay, up to an amount equal to 8 weeks of payroll based on employee retention and salary levels. Meaning, the idea here is to provide loans for small business so that they can keep the employees employed and pay them salary. If they do that, they will be entitled to a forgiveness of the loan completely up to 8 weeks of payroll. And you'll see that there's a bit of a discrepancy in this time period that employers really should be very careful of. They get to apply for 2.5 months of monthly average wages, which is more than 8 weeks. It's 10 weeks at least. So employers need to be very careful that only 8 out of those 10 weeks are going to be subject to a possible forgiveness. 2 weeks of those expenses are not going to be covered for forgiveness. Small businesses and other eligible entities will be able to apply if they were harmed by the COVID between February 15 and June 30th, and loans are available only through June 30. So now, excuse me, now would be the time to apply for the loan. The other major component here is the Economic Injury Disaster Loan or the grant that's afforded to small businesses as well. Here, small business can access working capital, again through the SBA, up to $2 million to help with a loss of revenue, to provide for paid sick leave, maintain payroll, meet increased costs of materials, rent, or mortgage. And interestingly, under the EIDL loan program, the business would get an advance payment of $10,000, which does not have to be repaid if they are declined or refused the loan. So this is different from the paycheck program, okay? Understanding that this is a loan that is normally administered by the SBA, but just expanded to cover the pandemic period. So these loans are typical of the SBA loans and need to be repaid, except there's this provision that any advance payment up to $10,000 does not have to be if the business has applied for the loan, but cannot or is not approved. Another component of the CARES Act is the Small Business Debt Relief Program. Here, the SBA will cover loan payments on their loans, including principal and interest and fees for 6 months. The loan will be forgiven if the employer continues to keep employees or hires them back and uses the funds for covered expenses. This is similar to the Paycheck Protection Program. But here, self-employed individuals with no employees are also eligible. Okay, so there are various different types of loan programs, some administered through the SBA, some not, some part of their program, others not. But essentially what they're getting at, again, is trying to keep businesses operating and covering the cost of payroll and other expenses to keep the business operating. Now, this is interesting. Under the CARES Act, there's some relief for retirement plan participants. That would be employees, individuals. The law says that any COVID-related distributions and withdrawals are not subject to any penalties for withdrawal from their retirement plans if the employee, spouse, or dependent is diagnosed with the virus, or if the employee is not diagnosed but incurs financial hardship from being quarantined, furloughed, laid off, or suffers a reduction in work hours, or the employee is unable to work, is unable to work due to a lack of childcare, or the employee's own business had to close or reduce hours. In any one of these COVID-related instances, if the employee, the individual, had to withdraw from their retirement plan to cover these costs, those withdrawals would not be subject to any kind of withdrawal penalty. And they are limited. They can take up to $100,000 from their 401k without any early withdrawal penalty. The CARES Act also expands unemployment insurance to provide for temporary coverage for employees who have exhausted their entitlement to regular unemployment, or to those not eligible, such as self-employed and independent contractors. So remember, you are normally only entitled to 1 year's worth of unemployment insurance after you are terminated from work. So this expansion of the program actually enables those employees who have been off of unemployment after the year has been exhausted to receive additional compensation. Okay, and also for the first time, self-employed individuals and independent contractors are also now entitled to unemployment. However, it's covering only a 39-week period. So it's not the full 1 year, 52 weeks, but only 39 weeks of benefits. And under this program, the amount of unemployment insurance, or I should say compensation, is $600 per week for up to 4 months to individuals that are collecting regular unemployment compensation. So again, this is an increase over the maximum right now, which I think is about $350 per week. Under the CARES Act, there are these rebates that everybody has heard about that are due to all individuals if they meet certain requirements. The direct payments from the government to individuals based on their 2018 or their 2019 tax filings would entitle them to $1,200 per person, or $2,400 if the family is, if the individuals rather are married filing jointly, and $500 per child under 17. Eligibility, however, is limited to US residents only, and they have to have an adjusted gross income in either 2018 or 2019 of $75,000 for an individual, $150,000 for married couples filing jointly, or $112,500 if they are head of household. If your AGI is more than 75 or the other limits, then the rebate is reduced by $5 for every $100 over 75,000. And if your AGI is over 99,000, then, or the other limits are 198 or 146.5, you would not be eligible at all for the rebate. Okay, some other minor components to the CARES Act is the Employee Retention Tax Credit. Again, another employer tax credit against employment taxes for keeping the workers employed. Here, the credit is up to 50% of wages to $10,000 per employee annually. And then there's the delayed employer payroll taxes, which means that the employer can defer payments on the employer's portion of Social Security and Medicare tax paid over the following 2 years. So for those portions that are not forgiven, as we talked about before, the employer portion of Social Security can be deferred for 2 years. All right, and I think finally, again, under the CARES Act, there's additional provisions for coverage for COVID testing. Tests are covered at no charge to the individual or to group health members, and there's no charge for preventative services to mitigate the spread of the virus. And it also may be possible under the CARES Act to receive coverage for telehealth services. All right, I think that pretty much covers the laws, and I'm sure there's probably questions which we will get to in a few minutes, but I did want to point out a couple of problems and pitfalls that have arisen in the last few weeks. Believe it or not, it feels like a lot longer somehow, but it's only been a few weeks that we've been in this situation. But already problems everywhere. So just to point out a few. There's a big gap in the paid leave law. In that employers with over 500 employees are not obligated to any of these paid sick leave days or expansion of family medical leave, okay? And those employers with 50 or fewer employees potentially could be exempt if they qualify. So that means only employers that have employees between 51 and 500 employees are obligated. But that leaves a large swath of employers that are not obligated by these laws. If they have more than 500 employees, none of this applies to them. If they have less than 50, they potentially could be exempt. So that's one of the gaps here. And believe it or not, there are lots of employees that fall in either one of those categories. Another problem that has arisen is employers have been reducing their hours for their workers and furloughing employees. If you're not familiar with the term furlough, it's different from being laid off in the sense that furloughing means that employees, there's this prospect that they will be back to work with the employer and that they're only off temporarily. So a lot of employers have been furloughing employees with the hope that they will bring everyone back or reducing their hours. The problem is that if they don't understand the rules and the conditions of furloughing employees, some furloughing employees are actually working remotely from home. They've been told that they've been furloughed, but they are still remotely working. They need to be compensated regardless of what the employer, how the employer designates them. Another issue that has arisen is exempt employees, meaning those employees that are not entitled to overtime wages. Usually they're professionals, they're administrative executives. I'm going to assume for the moment that many of you are familiar with the term exempt employee. Well, you know, if they have a reduction in hours, it doesn't matter that they're exempt. They're still entitled to be paid for each week that they work. And similarly, non-exempt employees are entitled to be paid for the number of hours that they work. All right, so there's no getting past compensation for employees that have had reduced hours or have been furloughed. Paid time off, vacation pay, if employees choose to take their vacation pay or vacation time now, and they are entitled to be paid for it, they're entitled to it regardless, all right, depending on the employer's policy. Health insurance coverage for furloughed employees must be maintained, okay? They're not laid off. There's this prospect that they're supposed to be coming back, and so all benefits, salary can be stopped, but health coverage cannot be. The problem is that the employers need to be very careful with their policies and look to coverage limits, because many healthcare insurance coverage policies are dependent upon the number of hours that employees work. So if there's a reduction in hours or people are furloughed, the employer needs to look at their policy to see if there are any limits on coverage. And if there are limits, they need to inform the employee. Similarly, COBRA rights. If an employee has been furloughed or terminated, well, terminated, they would be entitled to their COBRA. But if they're furloughed, they must look to their insurance policies to see if coverage is in any way limited. And lastly, as I said before, furloughed employees have a right to unemployment compensation. So if the furloughed employee wants to collect unemployment, they should be entitled to. And the employer should not be attempting to dispute a claim for unemployment insurance if the employee has been furloughed. Another problem, the Affordable Care Act, otherwise known as Obamacare. There's provisions that apply to applicable large employers called ALs. These are 50 or more full-time employees. Okay? These employers are required to offer adequate and affordable health insurance under Obamacare. So the question is, if the employees are returning to work, are they returning as continuing employees or new hires with a break in service? This becomes a very particular question, but an important one because it affects all employers with 50 or more employees, of which there are many thousands of businesses. The significance here is that depending on how you categorize the returning employees will affect the time period by which the employer needs to afford the insurance coverage. And if they don't do it within a timely fashion, they will incur IRS penalties, which could be significant. Another problem, lawsuits and potential lawsuits. Already, lawsuits have started based on denying leave. In this one case in the Eastern District of Pennsylvania, in federal court, the plaintiff is a former executive at Eastern Airlines, and she's a single mother. On March, I believe it was March 20th, she needed to take leave, and she needed to take leave because of the care of her children who are now home from school. She advised HR on March 23rd that she needed to take the leave time or have some flex time, and she thought that she was entitled to it under the new laws, and the employer disagreed, and on March 27th, 4 days later, they terminated her. That is now in the courts to be decided. So that's just one of a multitude of cases that may arise in the next few weeks by employees who have been denied an accommodation. I think employers need to be aware that they must fulfill accommodation obligations under the FFCRA, the EPSL, and the FMLA. So let's not forget that the accommodations are necessary. They're obligatory under those particular laws, and they will apply. And lastly, these small business loans that I referred to earlier, that should be in theory forgiven. Nothing is unconditionally free. The loans are forgivable if the conditions are met. But what's the problem here? The problem is that first, these employees may not be able to come back, or the employer may not be able to take them back. And if that's the case, all that loan money that they receive from the SBA is not forgivable and it needs to be paid back. Or the employer could have closed in this period of time. It's now been almost 2 months that people are out of work and businesses have been closed. They may never reopen. If that's the case, they took loan money, that money is not forgivable. That has to be paid back. Employees may not want to come back. That's another potential issue, in which case the employer really is at a loss. So, and lastly, all I will say is that with respect to loans, a lot of businesses find it again as some opportunity for free money, but it's not if they don't meet the conditions, and what they will be saddled with after this is just more increased debt, debt that maybe they're already incurring prior to even the pandemic. So I think that concludes really my presentation. I hope I haven't gone too long on this. As I said, each one of these issues can be discussed in a webinar all unto themselves, and I'm just trying to provide an overview for everyone. So at this point, if there are any questions, I haven't been following the chat.
It's all right. I will help you, Albert.
Okay.
Thank you so much. This was very informative overall for all of us, for all purposes. We've got quite a few questions.
Okay.
So there's one category of questions that have to do with layoffs, and obviously on the other side of it, looking for work.
Mhm.
So there's a question about how the company makes a decision in prioritizing how they lay people off,
Mhm.
and if there is any recourse for wrongful dismissal, let's say, or wrongful separation,
Mhm.
if you feel that you've been prioritized over because of the age discrimination or any other reasons that the company chose you over others. So how is this done?
Okay, so let's not forget that all of the pre-existing laws are still in effect. So that means that employers cannot discriminate against employees on the basis of any of the protected categories. If they're protected by statutes, state or federal statutes, they're still protected. They cannot be discriminated against. If they want to take FMLA, they're entitled to take FMLA regardless of all of these new laws that are in place. So the short answer to the question is, it's not a question of prioritizing, it's a question of whether or not the employer has actually committed some wrong legally by laying off the employee. If the reason for the layoff is because there's simply no business or the business is now closed, I find the employee will be hard pressed to make a claim that they've been wrongfully discharged. If they otherwise violate the law in laying off certain employees, for example, there's the Age Discrimination Act. So if the employer decided to lay off only those over the age of 40, well, regardless of the pandemic, that would be something that the employer is not able to do. So that would potentially cause a discrimination suit. So we have to bear in mind that those laws exist, they still exist. These laws are aimed at providing some additional relief financially, economically. But if the employer is stuck and just simply doesn't have the business to accommodate all of its employees anymore, they can certainly lay them off without any recourse by the employee rather.
Okay, thank you so much. One question from John here, that you mentioned mandating sick leave allowance due to COVID. If an employer gives unlimited time off, is there any further action they need to do to say in compliance with sick leave allowance other than FMLA expansion?
Is there anything else that the employer needs to do?
Yes, so the question is.
Yeah, so if the employer is allowing for indefinite paid leave, obviously it's potentially more than the laws are obligating employers here. So there's nothing else that they need to do, no.
Other questions here around free testing, etc. Glory is saying that if you go to urgent care facility, CTMD, etc., you still have to pay copay.
No, all copays, co-insurance, deductibles, all of this should not enter into the picture. The government is saying that these testing specifically for COVID now, not just for anything, just for COVID testing and diagnosis, should be free of all of that, those conditions.
Okay. So if there's somebody paid, that should be disputed as
sure, absolutely,
based on a provision. Okay, Gloria, I hope you've heard that. Question from George, and George is teaching finance. So, so his comment is around PPP. Can employers hire back workers part-time so that workers continue to get unemployment benefits and employers get partial PPP forgiveness?
That's a good question. I'm not 100% sure of what the answer is, but I can say this. Normally, an employee who comes back to work part-time would not be entitled to unemployment benefits, so long as they are working. So if they come back to work part-time and still collecting unemployment, which I would be very careful to say that they are entitled to do this, and if unemployment ever found out, the employee could be in very big trouble. So I hesitate to say yes or no. In terms of the employer being eligible for the PPP credits, I'm going to err on the side of saying no. Now, again, I could have 2 webinars just on the PPP program, at least 2 webinars. I mean, this is a program that's so fraught with conditions that it's very complicated to give a 100% absolute certain answer. My gut instinct would be that they would not be entitled to the credits.
So if you have a recommendation to people who have various, obviously, personal questions, it looks like there's so much complexity here.
Mm-hmm.
Should people consult employment attorneys like yourself, or where is the best place to find clarification on some of the specifics?
Okay, so the government websites are fairly good for employees to get some information from the employee perspective. Where it gets complicated is on the employer side. And there, the employer should really seek some kind of counseling or advice from employment attorneys that are knowledgeable in this area.
Okay, thank you. And there are a few questions about, for people who have been laid off, how to go about seeking a new job. And one of the things I want to say is actually on our Slack channel that I hope you all join, and we'll send you that information. We actually created a space for people who are looking for work, because there's lots of opportunities out there in different industries, especially if you're in HR. And some companies are growing really fast and continue to expand and hire. And Stella just posted the link to the Launchpass in our Slack channel. Please go there, and we're going to be posting employment opportunities for the community. And now to you, Albert, how do people go about looking for work in this type of environment we're in?
Anna, it's very difficult. It was difficult before. Even though the economy was doing well, there was a good number of employees out of work for a period of time, even prior to this. Now, supposedly, the unemployment rolls are approaching 30% nationwide. I don't know if there's a significant portion of those employees that are now on the unemployment rolls are ever going to come back to their former employers. I think that this is a whole new world situation where employers are going to find that maybe they didn't need the 100 employees that they had before, or the 50 employees that they had before. They can do with a lot less, maybe half their staff. So some will come back, others will not. And I got a feeling that this is going to be a long haul for us to reach the pre-pandemic unemployment rates.
So one thing I would say, again, there's a definite growth in certain types of jobs that have to do with technology, data, analytics, etc. And these types of times off are good times to upskill yourself, develop new credentials. First of all, you're going to be expanding your network, even quarantined through online offerings. NYU is online, definitely. And try to anticipate where that movement is going to be. In HR, we know that it's going to be in technology and analytics. Those jobs are going to be continuing in demand. And I think in addition to looking for opportunities, in which we are going to be sharing here in the community, definitely try to find time to develop new skills, try out new technologies, definitely bring data, and definitely dial into our Zoom call.